Kim, are you still there?
I am still here.
Just wanted to check to make sure you're good.
Thank you. I was going to text Fabiana to make sure that we had gone live, and then I was going to try and share content to make sure that we were good on that front as well.
Okay, let me know.
I just heard that the YouTube is live and up, and I'm still connected, so I will try to share content now and make sure we're still good.
Why is mine not? Oh, here I am.
Yeah, I'm not at lunch.
Do you see the PowerPoint?
Yes.
Yes.
Perfect, thank you.
Kimberly, good afternoon. This is Paulette Armstead. I just want to make certain I'm coming through.
Yes, ma'am, loud and clear. Thank you so much.
Okay, thank you.
Hello, this is Dennis Moore. Just want to make sure you have me in attendance.
Yes. Can you hear me?
I can.
Yes, thank you so much. I appreciate it. And I do see that we have a call-in user joining us. If you are just joining us by phone this morning, or I guess it's almost afternoon, if you wouldn't mind identifying yourself.
Jim White, W-H-I-T-E.
Thank you so much, Jim. I appreciate it. And before we get started, this is just a reminder for all of those on the phone, we ask that, or all of you on the Webex, we ask that only the task force members have their video up. And also the presenters, you're more than welcome to keep your video up as well. So throughout the meeting, please make sure that the only videos are those of the task force members and the presenters.
Well, great, Kimberly. Are we ready to get started?
If you don't mind, just 1 second, and then I just want to make sure we've got everything on our end, and we will start in just a moment.
Okay, thank you.
Hi, this is Bob Astalis.
Thank you. Anthony, you can go ahead and feel free to get started.
Okay, Kimberly, thank you so much first before we get started for you and the rest of the FCC staff for administering these meetings. So good afternoon. I wanted to thank and welcome everyone else to the Guardianship Improvement Task Force meeting. This is September 2nd, 2021. And I'm Anthony Palmieri. I'm the Deputy Inspector General and Chief Guardianship Investigator for the Clerk of the Circuit Court and Comptroller's Office in Palm Beach County. And I have the honor of being the Vice Chair of this task force. And I'm also representing and giving the perspective of the Clerk Statewide Investigation Alliance. And of course, I'm also giving the perspective of our citizens in Palm Beach County with one of the largest aging populations in the United States. Well, as you can see and hear, our chair, Ken Burke, was not able to participate today on video. My understanding is he's on by phone for a little bit, but not the entire meeting. And he has asked me to step in and administer today's task force meeting. So let's get started. I wanted to note that the 2022 legislative session in our state's capital does not officially convene until January 11th, but in just 18 short days, interim committee meetings for the 2022 session will begin. So this task force still has some work to do, and we need to do that as efficiently as possible, as we've been doing. But I think we're well on our way to find solutions to address some of the very apparent and problematic issues in Florida's guardianship system. As we're addressing some of those problems, I'm hopeful that this committee will also find a way to acknowledge some of the things that are going well in the guardianship system as well. In my opinion, we owe it to our citizens and our future citizens who are moving to the state of Florida every single day. We owe it to them to be as fair and accurate and balanced as possible. And there's no better way to achieving this than all together with multiple perspectives, including attorneys, judges, advocates, clerks, legislators, agency heads, and most importantly, from the perspective of people that were once served by guardianship, like Task Force member Michael Lincoln. This task force is quickly building upon the base that was set during our kickoff meeting, and then again during our in-person meeting on July 28th in Clearwater. We've gotten off to an outstanding start, in my opinion, and we continue to build. Our last two virtual meetings with the case studies and national trends were outstanding, and anticipating that today's meeting and the presentations will turn out to be just as value added. So in a moment, we're going to hear from Shante Jones, the Executive Director of the Office of Public and Professional Guardians, on behalf of Secretary Prudhomme of the Florida Department of Elder Affairs. And then next up, we have Court Monitor Winter Solomon Colbert, retired Judge Stephen Cohen, and Attorney Paulette Armstead with presentations about one of the tools in the court's toolbox to monitor guardianship proceedings. All of this information, along with our upcoming virtual meetings and presentations, will reach its crescendo during our in-person meeting on September 23rd in Tallahassee. As Clerk Burke, as Chair Burke, so eloquently pointed out last time, the in-person meeting on September 23rd and this task force's report to the legislature should be viewed as a starting point. We've got to figure out a way to take all this momentum that we're building, all of the focus to improve the system and the focus on protecting and leveling the playing field for our most vulnerable citizen. This has got to be carried out and into the future and well past September. Okay, so for a few housekeeping notes. Notes from the meeting were previously provided for the August 19th meeting, and I wanted to take a moment and thank Karen Lamb in Clerk's Burke office in Pinellas for taking those very good and detailed notes. The notes and the other materials have been posted on the website under public information. As a quick reminder, all of the meeting materials, as well as the recordings of the meetings, are located under public information on the website. So the website is all one word, and it's Guardianship Improvement Task Force.com. That's Guardianship Improvement Task Force, no spaces, no special characters, .com. Okay, Kimberly, will you please take a moment to explain the process for our public comment?
Yes, sir. For today's virtual meeting and going forward, we will reserve the final 30 minutes of each meeting to take public comment. As with previous meetings, we have a process for today, for the submissions today of written or verbal comment. For those who would like to submit comments in writing, please visit the contact page on the Guardianship Improvement Task Force website. The link is included on the slide before you. For those who would like to submit verbal comments today, in the description of today's YouTube meeting, you will find a link to join the Webex application directly. If you're unfamiliar with Webex or you have not used it in a while, we would urge you to allow your computer the opportunity to download or update any necessary software during the course of today's meeting so that you are able to present your comments to the task force later on. In the description section, you will also find a way to connect via phone only if you are unable or do not care to connect directly to the Webex application. Based on the number of individuals wishing to comment today, we will start by allotting 3 minutes per speaker. Note that I will be keeping time and will alert you verbally when you have 30 seconds left, 10 seconds left, and when your time is up. We apologize in advance for any interruptions, but believe this is the best way to handle this during a virtual meeting. Our process will be to take those individuals who have joined via Webex. Please use the raise your hand feature, which is located to the right of your name next to the mute option, and we will take you in the order that your hands are raised. And then we will take the comments from our call-in users. At that time, we will unmute the phone lines and ask you to speak one at a time. And that is it, Mr. Vice Chair.
Okay, well, thank you again, Kimberly. Can we please take a moment for a roll call? I know we have 2 task force members who were unable to join today's meeting and have sent representatives on their behalf. So I ask, when the name of the member you are representing is called, please indicate that you're here and state your name.
Thank you, Anthony. I will go ahead and I'll start with roll call. The Honorable Ken Burke.
I'm present, thank you.
Thank you. Anthony Palmieri.
I'm here.
The Honorable Crystal Kinzel.
Here.
The Honorable J.D. Peacock.
Present.
Senator Jennifer Bradley. Representative Colleen Burton.
Hi, I'm here for Representative Burton.
Thank you. And just for the record, that is Brittany Rembrandt.
Brittany Rembrandt, thank you.
Thank you. The Honorable Michelle Morley. Sean Cadigan.
Here.
The Honorable Jose Rodriguez.
I'm here, present.
Sandra Brennan.
Present.
Shannon Miller.
Present.
Gina Rossi Scheissman,
Present.
Tamara Caribin,
Present.
Viviana Bonilla Lopez,
This is Olivia Babbis filling in for Viviana.
thank you, Olivia. Hillary Hogue, Michael Lincoln McCrae, Zane Smith,
Hi, this is Jeff Johnson filling in for Zane Smith.
thank you, Jeff. Dennis Moore,
Present.
Mike Donovan,
I'm here.
Richard Prudhomme.
Hi, it's Shantae Jones. Secretary Prudhomme.
Morning, Shantae, thank you.
Thank you.
Bob Azalitos,
Stalis, I'm present.
thank you. Karen Murillo,
Good afternoon, I'm present.
thank you. Mr. Chair, we have a quorum.
Excellent, excellent. Okay. I would like to begin today's first presentation. Shantae Jones.
Anthony, this is Ken. I'm
Yep.
going to interrupt. Hillary texted me and says she's not able to get into Webex. So can someone work with her, please? Thank you.
Kimberly, did you get that message?
Yes, sir, I just need to do some of the technology things on my side first to get the presentation up, and then I will try and get in contact with Hillary.
Okay, thank you so much. So let's get started with today's first presentation. We got Shantae Jones, the Executive Director of the Office of Public and Professional Guardians. Again, she'll be representing on behalf of Secretary Prudhomme. Shantae Jones was appointed as the Director of the OPPG in December 2019. In addition to her Juris Doctorate and being a Florida Bar licensed attorney, Shantae has served as a guardian ad litem and has more than 20 years of corporate and management experience, having previously worked for a large wireless network operator. She is also a Florida Supreme Court certified county mediator. Shantae will be presenting on the education, regulation, and discipline, if necessary, of professional guardians. Now, since we have a packed agenda and we want to be respectful of everyone's time, as with the public comment, Kimberly, will you please be keeping time and alert Shantae verbally when she has 5 minutes left, 3 minutes left, and 1 minute left. And with that, I'd like to welcome Shantae Jones.
Good afternoon. Thank you, Anthony. And thank you to the task force and everyone present today for the presentation and to just have a discussion on the oversight of professional guardians. Slide, please. So I thought I would start with just the basics. As I know everyone on the task force is well aware, but we may have some that are listening in or visit or watching, that I wanted to start with the basic. What is guardianship? And so guardianship is a legal relationship that's created by the court between an individual determined not capable of making certain decisions regarding certain aspects of their life. That could be regarding the property and the person or the organization that's appointed to make those decisions for that individual. Okay. Slide, please. What type of guardianships are out there? One of which is family guardians, and family guardians are typically family, friends, or volunteers that serve less than 3 wards or individuals under guardianship. We do have a classification of professional guardians. Those professional guardians are paid from the assets of the person under guardianship, which the statute currently calls them wards. Or we may have a public guardian that serves indigent individuals under guardianships that are paid by the state or the county. Slide, please. So the Office of Public and Professional Guardians, of which I'm the executive director, we have several duties that are assigned to us statutorily. Some of those are listed here. We contract with 17 public guardian offices statewide to serve our indigent persons under guardianship when there's not a family member or friend or volunteer willing or able to serve. We are also responsible for the registration and education of all professional guardians. We process complaints against professional guardians. We also investigate complaints that are deemed legally sufficient. If appropriate, there will be disciplines for those professional guardians that are ultimately found to be in violation of that law or the standards of practice. Currently, there is no statutory authority to regulate family guardians on any level for the OPPG. Next slide, please. So within that regulation of the professional guardians, there are several items that we are monitoring and that must be kept up to date and to be in compliance with the statute. And that's the completion of a 40-hour course. So guardians are going through this 40-hour course of initial instruction and training. That 40-hour course is preparing them for the state exam. The state exam is testing 10 core competencies for a guardian. They're germane to the action of guardianship or how to become a guardian. It is interact with the courts, their responsibilities, and also going over statutory responsibilities. So all of that's covered within the course, and it's preparing them for the state exam. Individuals must also pass that state exam with a 75% on both parts of the exam. The exam is comprised within those two parts of National Guardianship Ethics and Practice, as well as Florida Law and Procedure. And so in order to be deemed competent in that, they must pass with a 75% for each part of the exam. After that initial coursework is done, passage of the exam, professional guardians are required to register with the OPPG. They're showing us that they have taken that course, passed that exam. They're also submitting at their own expense a credit screening, a level 2 background screening, which includes FDLE fingerprints and a criminal history check. They are also supplying proof of a blanket fiduciary bond. In addition to that, continuing education is required 16 years biannually. So every 2 years, they're required to continue education. The credit screening is also done every 2 years, as well as the level 2 background screening is done every 5 years as well. Next screen, please. 5, please. So the complaint process, as I mentioned, we do accept complaints from a professional guardian about a professional guardian, and we have several ways that those complaints can be filed with us. Here, you can give us a call. There's a hotline where we take those calls. Any complaint that needs to be filed, you may email those to us here. Our email is there. Fax, you may submit those online through our web form or write us. So there's so many different ways that an individual can file a complaint with the OPPG, and then we'll take our due care to review those complaints for legal sufficiency. I will mention that sometimes we get complaints that are very voluminous that it is often, anywhere from 10 to 40. We've even received one, in several hundred pages. And so we will take whatever information in whatever way an individual would like to give it to us to have their voice be heard and their complaint be reviewed. Next slide, please. So as I mentioned, we receive those complaints in various ways. The first step is to review that complaint for legal sufficiency. And legal sufficiency is what we're looking for. however the complainant sent to us, we're looking to see if the allegation or the complaint contains ultimate facts that show there's a violation of the standards of practice of a by a professional guardian. And so when we're looking at those, we are taking that due care and we're looking at them individually, each one on its own, on the face, for that legal sufficiency. There may be instances that we will contact the complainant and ask for additional information. We may look for additional court documents for additional information because we're wanting to find that legal sufficiency to show that the conduct or that is the alleged conduct of the guardian has violated a standard of practice. The standard of practice that we speak of, those are detailed in Chapter 58M-2. They're listing there several subsections, about 22 of the standards of practice that were established by the department of how the guardian conduct should be. It's very detailed on what those are there. Once legal sufficiency is determined, we do refer our investigations to the Statewide Investigative Alliance, the SIA. Those investigations are conducted by the clerk of courts. The investigators are experts in Florida guardianship law. They have inspector general status. They have access to confidential court records, and they have a long history of auditing and investigating guardianships. As many of you guys know, Anthony Palmieri serves as our liaison for that, and he takes those complaints that we forward to him. He's also taking another additional look for legal sufficiency and determining where the best fit for the clerk's office or the inspector general to assign those. And there's a priority given to those, and then we are assigning those out as well. Next slide. So we're reviewing after the investigative findings. So once we've referred those over to Anthony and we've had the investigation done, we then have the investigative findings come back to us and we determine if there is any discipline that's deemed necessary. So there is an issuance of a reprimand or letter of concern. There could be a requirement to undergo remedial education. There may be restitution, to pay restitution as appropriate. Suspension or permanently revocation of the guardian's licensing, which would mean that they are no longer to provide guardianship services in the state. Some grounds for discipline that there's an exhaustive list of some of the grounds that would be for discipline, and they're listed in the statute 744.20041. But then there are some, just to name a couple, they're making misleading, deceptive, or fraudulent representations or related to the practice of guardianship, violating any rule governing guardians or guardianships adopted by the OPPG, being convicted or found guilty of or entering a plea of guilty of nolle contendere to, regardless of the adjudication of a crime in any jurisdiction, failing to comply with educational requirements that we spoke of before. So there's an exhaustive list of some of those grounds for discipline. And if we get that report based on the allegation, those investigative findings notifies us that those are deemed to be substantiated. Next slide, please. So there are some operational improvements that we have been doing within the OPPG that I wanted to take some time to talk about as well. And some of those are process improvement. So we're looking to ensure that there's strict compliance of the professional guardian as far as their registration requirements. We find that it's easier to help to get the things that we need in for those registrations every year versus doing that on the back end. So we've taken a lot of different touch points on the front end to get the guardians to remember the items that they need to get in for their registration. We have those listed on our website because we know that the judiciary, the general public, they like to know who's in compliance. And so we have that listed on our website, the Department of Elder Affairs website. So it's a registry. So everyone is clear who's registered, who's in compliance. And so we want to make sure that those little things don't get through the cracks and that guardians are ensuring that they are complying with the requirements for credit screenings, for their bond renewals, for education requirements. And so we're doing that as well. We've also implemented, as of the COVID-19 pandemic, virtual monitoring of our public guardian programs. Prior to the pandemic, we would go out to the public guardian offices and do similarly as an audit, just checking to see how things are going with their wards, make sure they're responsive to the wards and those under guardianship, as well as all of their files are intact. And so we've implemented virtual monitoring to allow us to be able to still monitor our public guardian programs, as well as going out to visit some of those under guardianship in certain facilities. We previously would do those visits face-to-face. Now we've adopted where we do those via Zoom, FaceTime, to ensure that we're still being able to monitor the public guardian programs appropriately. Another operational improvement that we've been implementing is rewriting the 40-hour course curriculum. As I mentioned before, all professional guardians must take and pass the course as well as the exam. So we're in the process of rewriting that 40-hour course curriculum. It'll allow us to make sure that it's clear and concise and up to date with any additional legislative changes that have happened since the last drafting of that curriculum. Also in the process of developing a robust catalog of continuing education courses. I'm finding certain courses and subject matter need to be reiterated over time, and they need to be fresh. And so making sure that that catalog is something robust and that it has quality education that gives the guardians the education that they need, that's germane to guardianship, and allows them to also keep abreast to any technology changes, any statutorily changes that may happen that may not have been covered in the 40-hour course because those are continuously changing. Next slide, please. And so lastly, one of the operation improvements that I've been working is for relationship building, opening the lines of communication with the judiciary. In addition to that, with stakeholders across the state, complainants, our guardian advocates. I take due care to have those conversations. And I find that having those conversations allows me to be able to determine how, thank you, how the guardianship, the legislative changes, or what the legislative authority is now, how they're affecting our families and how they're affecting those under guardianship, and to take those back to see if there's anything that we can take back for OPPG and do our part to make it better that's within our statutory authority. Lastly, we've been doing more to improve the complaint intake, our investigations, and the referral procedures within our partnership with the Statewide Investigative Alliance, and improving that, make sure that we're asking the right questions on the front end to determine that legal sufficiency that I spoke about earlier, to make sure that we're asking the right questions, the who, what, when, and why, and getting those details if they're not provided to us initially, that we're asking those questions and taking the due care to look at each individual complaint for legal sufficiency, so then we can get those over for investigations and take appropriate disciplinary action if needed. If there's any other question, oh, sorry, next slide. I think any questions, I will open that up. I think Kimberly will help us manage those, or Anthony. But thank you so much for your attention today.
Well, thank you so much, Shantae. Yeah, I think we have about 10 minutes that task force members are able to ask questions, and I'll get us started. Can you explain who with the OPPG staff ultimately determines legal sufficiency, and what are their qualifications for doing so?
Okay, thanks. So I do have a assistant general counsel that assists as well for determining legal sufficiency. So we're reviewing those, and she's a Florida bar attorney. She's very extensive in her education as far as being a past litigator. She's also worked with the Guardian Ad Litem program as a senior attorney. So she is a social worker at heart, but she does have the legal expertise to do that, determine that legal sufficiency along with myself.
Just to remind the task force members, I do see a few people raising their physical hands on video, but we ask that you please use the raise your hand feature, which is located to the right of your name. So if you go over into the participants view, you'll see a little hand and you can raise your hand. So Anthony, I'm not sure if you can see that. The first hand we have is Ms. Shannon Miller.
Yes.
Shannon, you're recognized.
Thank you. So I guess one of my questions is, with OPPG, has it ever been an option to, or considered, that you guys might take family guardians as part of your policing? Would that be something that OPPG could take on effectively? And has that ever been a consideration?
So Shannon, thanks for the question. I am not familiar if that had been a consideration or how that was determined. It's a little bit before my time, so I'm not sure. That may be something, I guess if this task force decides that's maybe something should be recommended, but we're only able to manage today the authority that's given to us. So we're focused on that. And today it's just not there. I'm not sure any background on that decision or why that was made. I don't know, Anthony, do you have any thoughts on that or any experience?
I've never heard that before, but yeah, it'd be an interesting concept. Certainly would increase volume.
Yeah, I will mention that I do know that we've had some inquiries about that, about education-wise, and I know that some family guardians have taken a 40-hour course, but as far as us regulating them, no, that had not come up previously.
Would it be difficult to expand OPPG to take on that additional hat?
Not sure. I know that regulatory agencies generally only regulate those that have registrations or licensing. So I think it would be a bigger question to determine if family guardians would then become registered, right? Would they have to be registered the same way that professional guardians would? And so I think that's maybe the question or the different there, that maybe the like the decision tree, right? So I don't know that to be the case that would happen.
Thank you.
Yeah.
Thank you so much for your question, Shannon. Kimberly, I don't see any other task force members' hands up. Do you?
Sorry, Anthony.
Yes, Hillary. Yeah, Hillary is logged on as Diane. It's not her name, but she is a task force member.
Okay, Hillary, you're recognized.
Good morning, task force members and members of the public. Sorry, I was a little tardy, so I will try and ask two, but I'll ask the most important one to Shantae. Good morning, and thank you for your presentation and the time you invested in getting it going. Does the Office of Public and Professional Standards, Office of Public and Professional Guardians, do you publish statistics on discipline? And if the answer is yes, phenomenal. where can the public find it? And if no, why not?
Okay, so no, we don't publish that information today. We don't have a statutory requirement to do that. And I don't know if that's why that decision wasn't made to do that, but we only notify, we're required by the statute to notify courts of those. So we do that if there is a suspension or a revocation of their registration, but there's not a catalog, so to speak.
Right, and you know, when the public gets letters, and you know, quite often recently, fantastically as it is, you know, when a complaint or allegation is substantiated, the template is basically the guardian was notified of the findings of the investigation as well as the discipline being imposed by the OPPG. Further substantiated allegations of conduct inconsistent with the Florida guardianship law may result in further administrative actions. Why isn't the complainant at least getting the information as to what the discipline is? Because it's really low and it's really high, you know, a slap on the wrist or getting suspended. So why aren't family members getting to know, or the complainant, what the discipline is?
Well, I think complainants do ask for those records. So they are public records to see the specific discipline that's imposed by the case. The question is more in the vein of why do we not automatically provide that information?
Right.
Is available upon request. So it is absolutely available upon request.
Perfect. And then finally, just because I'm here for the wards and their family, you know, we see guardians and we see attorneys actually being rewarded fees from the guardianship bonds when they violate the bond. We have never seen an estate reimbursed when a guardian acts fraudulently. Why does there always seem to be a double standard?
Well, that's a case by case scenario, right? So
yes.
we necessarily I can't speak to that on a holistic, because that's a specific case by case scenario that restitution may be required depending on the of the allegation being substantiated. I can't say that has never happened, because it has happened, and it has happened since I've been here. But I don't know anything prior, you know, of course, to me being here, if that was, you know, that would be based on the specific that case. So it has happened before.
I understand.
Thank you.
I know Anthony.
Thank you so much. Yeah, I wanted to get to Tom Hall, who's a task force member, Hillary, just to think we're running out of time a little bit. Tom?
Thank you, Hillary.
Tom Hall? It looks like you're unmuted now, Tom. Are you there? And as he's sorting out his issues, yeah, let me, there's another question about how is the bond, besides the statutory term, you know, of what the bond is set out, how come it's not changed for, let's say, a multi-million-dollar estate, Shantae?
By the fiduciary, the blanket fiduciary bond?
Yes.
Well, that's actually, the blanket fiduciary bond is required statutorily, so that's already set. However, when there are assets for a specific person under guardianship, the courts can deem that a surety bond is required based on, and they determine that amount based on the assets of the person under guardianship. So that's a little outside of the scope of OPPG. We're just ensuring that you have that the guardian has that blanket bond. But the courts absolutely have that discretion to look at specific assets of the person under guardianship and mandate that the guardian has a separate bond based on that property or those assets value. And so that's done within the courts.
Thank you so much. Let's see if Tom got his audio issues resolved. Tom, are you there?
I just got an email from him. I think there could be some just technological issues, but Tom, I'm going to request that we maybe submit those your questions via email, just because I am worried about time. So I want to make sure that we give the next presenters their fair amount of time as well.
Okay, thank you so much, Kimberly. How much time do we have left for this segment?
We've pretty much exhausted it, and then so I do believe that we need to move on.
Okay,
thank you so much, Shantae. I appreciate you.
Thank you so much, everyone.
Thank you.
Thank you so much, Shantae. So for our next panel, we have invited a well-rounded panel to speak on the topic of court monitors. Now, to accommodate scheduling, we're going to go a little bit out of order from what was on the agenda. First up, we have Winter Solomon Colbert. Winter graduated from the University of Central Florida in 1984 with a degree in criminal justice and has worked as a court program specialist, a court monitor, for the past 16 years. Her prior employment includes child protective investigations, probation officer, and residential advisor at a mental health facility. She is a certified court program manager and is one of only 1,154 fellows of the National Center for State Courts Institute of Court Management. She's also a National White Collar Crime Center certified trainer in elder exploitation. Next up is going to be attorney Paulette Armstead. Paulette received her Juris Doctorate from Florida State University. I know Clerk Burke is going to be happy with that. And has been an attorney since 1986. Currently, Paulette's practice is restricted to serving as the court-appointed attorney solely for the establishment of guardianships in the 15th Judicial Circuit Court and the 17th Judicial Circuit Court in Broward County. And then our last panelist will be Judge Stephen Cohen. Stephen Cohen is a sole practitioner in Palm Beach Gardens. He has been licensed in Florida for 40 years, in New Mexico for 21 years. During his career, he has served as a judge in Palm Beach County for 7 years when he covered the probate and guardianship division based on some of his prior litigation experience and his record in probate and guardianship cases prior to taking the bench. He has also served as a diplomat specializing in resolution of human rights cases involving Jewish political prisoners in the Soviet Union and helping to negotiate the release of Israeli soldiers or their remains from captivity. In such capacities, he's lectured throughout the world. Judge Cohen has served as court monitor in a number of significant cases in Palm Beach County and has recovered substantial sums of money for those wards. Additionally, Judge Cohen has served as an expert witness for the state of Florida's Department of Elder Affairs in a case against a professional guardian, and his testimony was cited by the administrative law judge in that case. Although it's not on his resume, I also want everyone to know that Judge Cohen has a very distinguished military service. So just like with the previous presentations, Kimberly will be keeping time and will alert you verbally when you have 2 minutes left and then 1 minute and 30 seconds left. And then questions are going to be taken from the task force members at the conclusion of the presentation. With that, I want to welcome Winter. Winter?
There. Can you hear me now? Okay. Can you start?
If you can maybe get a little closer to your microphone.
Is this better? Is this any better?
Maybe a little closer. Kimberly, what do you think?
I was going to say, I don't know if any of the other task force members are having trouble. It's slightly muffled, but I don't know, that could just be because of where her microphone is.
Okay. Is this any better?
Yeah, sounds good. Just project.
Okay, all right. I'm Winter Solomon Cuthbert. I have been the court monitor for the past 16 years in the 9th Judicial Circuit Court, and that includes Orange and Osceola County. Can you change the slide, please? Thank you. I am employed by court administration, and my supervisor is Assistant General Counsel Gwen Hawk, and she's been my supervisor for about the last 13 or 14 years. I am appointed to cases. The way I get my cases is I'm appointed to cases by the court. The judges in the Guardianship Division from Orange and Osceola counties appoint me. And I had experience before this doing child protective investigations for DCF and Seminole County Sheriff's Office. And I'm very knowledgeable about the social programs and things we have in Orange and Osceola and Seminole counties. I also provide education to law enforcement officers. I do seminars for them and to other community groups. Okay, so the way I get my cases, I'm appointed to cases, but I can get cases from the clerk's office, from attorneys who have a concern, and from the public. Any of these people can ask the court for an appointment of court monitor. If I get a phone call and someone has a complaint and they want something done, I will instruct them to write a letter, and I put that forward to the court. And if the court wants to appoint someone, they can do that. And if they don't think that it's anything that needs to be checked out, well, that's up to them too. Turn the page, please. Who pays for the court monitor? I am an employee of the state of Florida. So my salary is paid by the state of Florida. Depending on the financial status of the ward, the court in another jurisdiction might be hesitant to appoint a court monitor, because if that ward doesn't have any money, then how is that investigation going to be paid for? In Orange County and Osceola County, we don't have that issue. I am a state employee. Turn the page, please. Okay, 744.107 deals with who gets paid or who pays the fees for a court monitor. Unless otherwise prohibited by law, a monitor may be allowed a reasonable fee as determined by the court and paid from the property of the ward. No full-time state employee, county, or municipal officer shall be paid a fee for such an investigation and report. So that means me. If the court finds the motion for court monitor to have been filed in bad faith, the cost of proceeding, including attorney's fees, may be assessed against the movement. So if someone is acting in bad faith, then they can be assessed or required to pay the fees of the court monitor. The court may appoint the Office of Criminal Conflict and Regional Civil Counsel as monitor if the ward is indigent. Next page, please. Emergency temporary court monitor.
And you have 3 minutes.
Okay, the fees for that are pretty much the same. Unless prohibited by law, a court monitor can charge a reasonable fee. But of course, in my case, I don't charge anything. I'm a state employee, so I cannot charge. Next page, please. Benefits of the court monitor in our circuit. Me as a court monitor, my services are qualitatively similar for all protected persons. A consistent level of services is provided by using a single court monitor employee instead of a wheel. All of my wards are treated equally regardless of their wealth, lack of resources, or social condition. I'm the only salaried person that helps reduce all of the expense and the overhead for an investigation. Multiple county jurisdictions can benefit from one unified process and the pooling of talent, resources, programs. Not all counties have the same richness of resources. Next page, please. The court monitor acts as an investigator, applying for orders based on complaints, just as law enforcement officers do or would see orders for arrests or search warrants that are reviewable after their issuance. I do orders to produce if I need to get records from a bank or just about from anybody. I can do an order to produce and ask the court to sign that and then request my records. Due process issues are avoided since court monitors are required to file reports of their investigations under oath. Those reports will be set for hearing should the investigation reveal that the court needs to take further remedial action. In many cases, when I file a report, there's nothing else that really needs to be done. When necessary, the court monitor also assists with applying for services for the ward, as well as locating missing wards and guardians. Next page, please. Okay. Some of my investigations have found the following things. One gentleman who was an advisor to my ward, he was a financial advisor, had taken $5,000 from my ward, who was incapacitated. That $5,000 was reimbursed. One parent who took $100,000 from her developmentally disabled child had to reimburse those funds. We had a ward who he lost all of his life savings, $350,000, because his daughter bought a house. And she said he could live there if he wanted to. She had to reimburse that money. Retirement of a professional guardian when multiple payments were discovered based on a forensic accounting of hours charged over several counties. Award was reimbursed $43,000 after the bank improperly allowed access by the guardian. And I had an attorney who was a guardian who was required to reimburse award $50,001 after he was adjudicated guilty in a theft case. Next page.
Great, thank you so much, Winter.
Okay.
Paulette?
Okay, here I am.
And if you're not speaking, if you could mute your line, we're getting a little bit of background.
I'm trying to take care of that too, Anthony. I see who it is.
Paulette?
Okay, my job as court monitor is governed by sections 107 and 107.5 of chapter 744. And there are 5 tasks that the court monitor must complete. Number 1, investigate. Number 2, seek information. Number 3, examine documents. Number 4, interview the ward. And number 5, report his or her findings to the court. The way in which Broward County judges select and appoint court monitors to carry out the investigation is governed by Administrative Order 2019-26-PRC. And you all have a copy of that administrative order. But if you will look on page 1 of that order, you will see that the stated goal of the selection appointment process is to make the process, and I quote, fair and impartial, end quote. The appointment selection process has 4 steps. Step number 1 is that the applicant has to submit a written application detailing his or her educational background, work experience, expertise in an area such as accounting, investigations, legal, etc. Step number 2 in the appointment selection process of the court monitor is that the applicant has to participate in a mandatory interview. Usually this interview is with the chief judge of the circuit and or his or her designee. Step number 3 of the selection appointment process is that the applicant has to undergo a criminal background check and a credit check. And step number 4 is that the applicant has to sign a memorandum of understanding or it's a contract. Now, the second part of the administrative order deals with the removal and or resignation of the court monitor. And usually removal has to be substantiated with the failure to comply with Chapter 744 or failure to comply with the rules of the court. As for payment in Broward County, the compensation for court monitors is set at $55 per hour. If the ward has assets, payment comes from the ward's assets. On the other hand, if the ward is indigent, then payment can probably come from the Justice Administration or JAC, or in some cases, the court monitor can just provide free services pro bono. So what is a court monitor? When is a court monitor appointed? In Broward County, and in my experience as a court monitor, there are 3 groups of people who can request the appointment of the court monitor. Clearly, number 1, according to the statute, the court on its own motion can appoint the monitor. And a lot of times these requests to the court to appoint the monitor will come from the clerk's office, the auditors. I've had 1 or 2 come from the general magistrates, and the staff attorneys will ask the judge to do that. And those staff attorneys come from the general counsel's office. The second group of people who can ask or request the appointment of the court monitor would be court-appointed attorneys for the ward. And I've had 1 or 2 cases where that has happened. And the third group of people who can request the appointment of the court monitor would be concerned family members. And usually it's initiated with a letter to the judge from the family member alleging misconduct on the part of the guardian, or they're concerned about the care of the ward or the lack of care of the ward. And I've had two or three cases initiated with the appointment of the court monitor based on letters from the family members. So how is an investigation conducted? In Broward County, court monitors operate as what we call independent investigators. Independent means that I have no ex parte communications or contact with the judge appointing me to that case and or any other judge. Independent means that during my one-on-one interviews with the ward or with the guardian, no attorney is present. Independent also means that as a court monitor, I must stay within what we call the scope of the order appointing the court monitor. In Broward County, the judge actually will list or spell out the issues to be addressed or the issues to be investigated. Most times I am asked to locate the ward and report on the ward's well-being, or locate the assets of the ward and report the nature, value, expenses, and the balances. And I've had a case where I've been asked whether guardian is doing his or her job. Independent also means that I am available as court monitor to use the other court personnel like the court auditors or the program assistants. And a lot of times I'll do that and I'll ask them to pull files, docket sheets, copies of court orders. And if I need an extension, even though I could file one, I usually go through the program's office to get an extension. And I also have available to me court interpreters, especially if I have a ward or witnesses that do not speak English. So I have that as a court monitor. And the other part of being an independent investigator, independent monitor, is the confidentiality of the court monitor's report. No person or party will preview my report if it's in its draft stages. Once I am done with my report and ready to finalize my report, because it is a confidential document, I do file it as a confidential document. And of course, parties will then get copies of the report along with the attachments. So what does the court monitor's report contain? In Broward County, my court monitor report contains 3 parts. Section number 1 of the report contains the facts and the statements that confirm or deny the issues or the allegations that I was directed to investigate. Section 2 of my report contains attachments, exhibits, or documents in support of the facts that I investigated. And attachments could include redacted copies of the bank statement, copies of deeds, mortgages, that kind of thing. And section 3 of my report contains recommended actions that the court can take to protect the ward's person and or to protect the ward's property. And those recommended actions are listed in paragraph 3 of section 107 and paragraph C of section 105 and 107.5. The first recommended action would be the need for an accountant. I've recommended that the accountant be amended or that extension be given to file the accountant. A second recommended action would be freezing the assets or producing the assets that belong to the ward. I've had an opportunity to do that. A third recommended action would be removal of the guardian and appointment of a successor guardian of the personal property. I've done that in about 3 cases where I've actually recommended the removal and the judge went along with that. The fourth recommended action would be the issuance of a restraining order prohibiting a family member from interacting with the ward. I've never made such a recommendation, but after the judge has heard my report, read my report, heard other testimony, I've had the judge issue restraining orders in about 2 of my cases. Another recommended action would be sanction the guardian and or the guardian's attorney. Again, I've never made such a recommendation, but after hearing my testimony, reading my report and the testimony of others, I've had the judge sanction the professional guardian and the attorney with a substantial reduction in their fees. And of course, the last recommended action would be to refer the case to the state's attorney's office for criminal prosecution for financial exploitation of the ward. I've made this recommendation. In fact, it was 2 weeks ago, I had a case where there was financial exploitation, and the judge went along with the recommendation, and that case has now been referred to the state's attorney for criminal prosecution, where the family member exploited the ward for over $600,000 out of a medical malpractice settlement. Okay.
Well, thank you so much. Thank you so much, Paulette. Judge Cohen, you're up.
All right. Good afternoon, everyone, and thank you for the kind invitation and introduction. I'm going to try and answer a couple of questions that I saw pop up and skip through quite a bit on what you're seeing in the PowerPoint. And if we could go to the next couple of pages, we'll skip through it pretty quickly. But while it's happening is, one of the questions posed I saw in the chat is, why isn't the estate reimbursed? And I think one of the members asked that question. The times that I've been appointed as court monitor, that's been my stated goal. I don't believe in the theory of winning the battle and losing the economic war. I think that's going to further abuse the ward's estate and the ward's family. And it doesn't serve the statutory purpose or the legislative intent behind any of this. In fact, there have been a number of cases where I've been appointed as a court monitor where there is no one to go after despite the wrongdoing in terms of actually collecting funds. And I have just advised the court that I will not accept a fee because I don't want to take it from the ward's estate. So I think those that are being appointed to serve as court monitors need to consider doing that on a more regular basis. And that also addresses the question about how is a court monitor paid if the ward's estate does not have the funds. One is, as I indicated, is court monitors just shouldn't take a fee. We have a responsibility here. But secondly, I've proposed, you'll see in a later slide, that we amend a couple of the statutes. Right now, the statute provides that we can seek sanctions against a guardian to make the ward whole. And we have a statute that addresses professional guardians that has similar sanctions. But what we don't have, and it's problematic here in Palm Beach County, is where we have friends or family members that serve as guardians, and candidly, they see it as a feeding trough. And their attorney plays a role in it. I believe the statutes ought to be amended so that fees can be assessed against the wrongdoer, not just against the ward's estate. I've actually listed that as a requested form of relief in a number of petitions I have filed. And so that gets into my last comment, and it addresses what my predecessors have described. In terms of the role of the court monitor, we need to be totally independent. The only conversation I'll ever have with the court is at the outset, and that is to clarify any questions I may have. And you can go through the slides, Kimberly, at your discretion. But the only conversation I'll have with the court is to clarify any questions I may have as to what the scope of my investigation should be. And in fact, and Anthony knows this well, because a number of my referrals will be based upon a level 2 report prepared by his office. I don't always agree with what's in the report. I may find that some of the perceived violations aren't, and I actually may identify what I believe are some other violations that are not listed in the report. If the latter occurs, I will bring it to the court's attention without making any recommendations, but simply asking if the court wants me to investigate that matter further or not. But within my short period of time of preparing a report, I will prepare a binder for the court. The binder will have my verified report, any and all exhibits, copies of case law I'm citing in the report. It will all be tabbed, indexed, and hand-delivered to the court, and copies provided to the limited number of parties and counsel provided for under the statute. The court will then review it at its pace and set a status check hearing. On a number of occasions, the court has asked me to then file actions against the guardian and or guardian's counsel because based upon my recommendations, and I've had guardians and their counsel removed in a number of cases. So that, you know, in a nutshell is how I view my role as a court monitor. I have to be totally independent. My assistants kind of joke that when I get assigned these cases, I bury myself in my conference room and spread out all the papers and exhibits across a big conference room table, and I will disappear for a week or so and produce a pretty detailed volume and report. Fundamentally, I see it as a service to the community. I don't see it as a way of bringing revenue into my firm. This is contrary to what this is all about. And I'd like to believe that something like this is the rule rather than the exception, although I know the reason for this task force is because of abuses. But thank you. You'll see in the last slides, I recommend some statutory changes so we can recover fees from the offending parties if the offending party is not just the guardian. And I want to see the ward made whole and the ward's estate made whole. I don't want to be taking fees from the ward's estate. And candidly, I have never taken fees from the ward's estate unless it's been part of a settlement approved by everybody, and it's never been 100% of my fees. I just, as a matter of fundamental policy, will not accept that. And with that, I'll conclude my presentation.
Thank you so much, Judge Cohen. I've never seen someone produce such a large volume of work in such a short amount of time than my working with you. So, okay, well, I think we have about 10 minutes for questions to the court monitor panel from task force members. And maybe we can get started with Judge Rodriguez. Judge Rodriguez, did you have any comments or questions?
And Anthony, just before Judge Rodriguez speaks up, I do want to remind everyone that all of the materials from this meeting, I know we scrolled through those quickly, They will all be available on the Guardianship Improvement Task Force website. So if you didn't have a chance to review all of that as we were clicking through, it will be available on the website after this meeting.
Great. Thank you so much, Kimberly. Judge Rodriguez, are you there?
I am here. What I wanted to go ahead and emphasize is the fact that though Winter Solomon Cuthbert, whom I have had the pleasure and privilege to work with, is an employee of court administration, the organizational chart reflects that she is responding to an assistant attorney general for the circuit, which liberates her from having any contact whatsoever for any ex parte communications with the court. If there are any communications, it's basically the same type of communication that an investigating officer would have when they are seeking either an arrest warrant or a search warrant that's basically subject to challenge and basically subject to a hearing afterwards. The same thing, anything that she does requires her to file that report that's in the statutes. And of course, any redress is available through a hearing that follows a report where there is probable cause found. I know that when I've worked with her, there was a report that she issued that required me, out of courtesy, to contact the chief judge and then to let him know that we were going to refer this particular problem to the state attorney's office. So there is an independence there. And again, communications as far as our model, again, are free. There is no, I guess the only ex parte communications that occur are, as Judge Cohen mentioned, to get a handle on what is required, and in the event that there is an order that needs to be issued to stop or to be able to allow the banks to give information to the appointed court monitor, that happens. The one thing that I want to mention is that we are in a two-county circuit. And that presents problems because if you take a look demographically at Orange and Osceola, they're very disparate in terms of funding, funds, tax base. They're very different in, well, suffice it to say, we don't have the kind of resources or richness of resources that South Florida does, say, or a Duval County, a Broward, or a Miami-Dade, which is why one of the emphasis, I believe, of our system is that you get a salary, you've got consistent services, and to wax professorial, one of the things that you get from this particular way to enforce a court monitor going forward is that you are providing a consistent level of service that is subject to, well, no attack, because rich, poor, everybody is treated the same. Nobody is out because they can't afford the services. And what you wind up having is no creation of a class, an impermissible class, without a rational basis for distinguishing. You're going to appoint a court monitor because there are funds here, or you're not going to appoint a court monitor here because there are no funds. All of those issues are eliminated because you've got consistent services for all of the citizens. And again, Orange County oftentimes is the dog, and Osceola County is wagging its tail. You don't want to leave any part of that dog out because all of the dog requires to be treated. I've got Tiger Lily right here sitting next to me. So, but you want the entire dog to not have fleas. You don't want to treat one part of that animal different than the other. I think that to echo what everyone has said here, if we had an office, an independent office of the court monitor, say circuit by circuit, if the legislature were willing to go ahead and fund that, the same way that they funded the coordinators for drug courts, problem-solving courts, to do that, because there's a real commitment to take care of the vulnerables and have a separate office, separate and apart, and that being the office of the court monitor. Imagine the hole we could plug up where family guardians and complaints about family guardians that are not statutorily taken up by OPPG. That would be, I think, an awesome way to go about it. And I'll talk more about, and I'll do some writing
Thank you so much, Judge.
on another issue, meaning the reformation of section 440.17 of the Florida statutes, which deals with workers' compensations, with
Thank you.
working compensation, when a parent dies as part of a work-related accident, we do not have the ability to make sure that those funds go into a guardianship for that child and to protect them from the parents.
Thank you so much, Judge Rodriguez. We give you a little judicial discretion on your comments, but I would ask the other task force members just to ask a question and really reserve your comments to when we have the time to have a discussion. Now we have this very esteemed panel, and we want to make sure that we ask them those questions. I see four hands raised. I'm not sure what order they came in, but I'll go in the order that I saw them. Mike Donovan, do you have a question?
Okay, just short, and it's maybe that I just missed it, but do court monitors only exist in a couple of counties? Okay, I'm sorry, I just missed that. Thank you.
Yeah, thank you. Well, if they're all that quick, we're going to go through these questions pretty fast. Shannon Miller, did you have a question?
I do. So I heard very clearly from the court monitor, Ms. Armstead in Broward, that they do work very diligently not to engage in ex parte with the court, and also that their report is kept confidential until it's actually filed. And I'm assuming that that's done through like the portal, so everyone who's an interested party would receive that report. And I'm just wondering, for our other panel members, is that also your process? And then I heard Judge Rodriguez talking about exceptions to ex parte. Could you tell us a little bit what those exceptions to the ex parte are, when that happens, and what is your process for that?
Well, I'll answer your question in terms of the filing of the report, and thank you for the question. It does go through the portal. And I would assume, just like Ms. Armstead, although she and I haven't spoken about this issue, similarly, no one sees my report until it is pushed through the portal. And that includes the judge. It gets pushed through the portal at the same time that my original binder is being handed over to a courier service to take it to the court. I don't allow even the judge to see it before it is filed. I want to ensure that independence is maintained in every aspect I can think of. And then if the parties want, I will prepare at no expense full binders for them, including all the case law. I don't want anyone feeling shortchanged, but they will, through the portal, get copies of the report and any exhibits. The only thing they're not getting through the portal, copies of the highlighted case law that I'm providing the court.
As a judge, I can tell you that I don't know about the portal back in the day when I was serving. Okay, now I know because as an attorney and as a guardian ad litem, I do file. But I can tell you that I never saw the report until it was filed. Frankly, I didn't want to know until it was filed.
I don't ever give the court the report before it goes to everyone. There have been
court is the
times
last
when
to
I've
know.
been walking in the court with armloads of papers and reports, and the judge gets them at the same time that everybody else did.
Thank you.
Thank you so much. Up next, we have, I think this is Hillary's, Hillary Hogue.
Yes, it is. Thank you to the panel. Thank you, thank you, thank you. And I'll just briefly ask, considering that that you're getting paid by the government, okay? Is there any data? Are there any results that are published on statistics? A, and the second part would be, how many cases have been sent to the state attorney's office where you found a either for-profit professional guardian or a family member acting nefariously? Do we have any statistics on that throughout the state? And I'll ask that to Ms. Paulette, Ms. Winter, and Judge Cohen. Thank you.
Ladies.
But just for a point of clarification, Paulette's not paid by the state. So the only one paid by the state would be Winter. But Paulette, I'll let you comment.
Like I said in my presentation, just last month, a couple of weeks ago, I did make one referral. I don't know whether or not they keep data or statistics on it or anything like that. But yes, I did make the one referral.
Right. So in other words, we have no data whatsoever of findings by the court monitors and how many cases that the court monitors have pushed to the state attorney's office.
I don't know that. The court may very well, collect that data and store the data. I don't know. I don't know that.
Okay, and again, thank you. Judge Cohen, do you have an answer?
Well, I've never referred anyone for criminal prosecution. What I do, and it's not to say that I haven't believed that there wasn't criminal behavior, but if I do, I put it in my report. And as I indicated, the court sets a status check in the guardianship division and charges me then with whatever action it wants me to take. It may take independent action. But so I'm not aware of any reporting of statistics, and I'm not suggesting it shouldn't be, but I'm just not aware of any.
Yeah, quite worrisome. Thank you so much, everyone.
Up next, we have Karen Murillo. Karen?
Thank you. I have two quick questions. One is specific for Judge Cohen. You mentioned the sanctions being assessed against the wrongdoer and the application of that towards the court monitor fees. I just wanted to clarify if that has been successfully done in Palm Beach County with respect. So it's a perspective.
I appreciate the question. I think I'm the first one who's ever put it. It only comes up after the court has indicated it wants me to take some action based upon my report. And then I file what is in essence like a civil proceeding, a civil action within the guardianship proceeding. And that has been in my prayer for relief and allegations each time. And each time I've done it, there's been a settlement, and the settlement has always included payment of fees from the alleged wrongdoer, at least in part. I've never had a court rule on it. We've never gotten that far. But, the legislative intent is clearly that the ward's estate be made whole, and that's the argument that I use. But I've not had a court rule on the issue.
Thank you. And for all of the court monitors who presented, I'm curious at what stage you, if any, you are referring this information to DCF and working with and collaborating with Adult Protective Services.
Hello, please leave a message after the tone. Well, as soon as if I see that someone is in peril, their physical body being in peril, I will call immediately. That's my number one priority at that point. With it being exploitation, it's after I get the records that can verify that information.
You've got to remember one of the things that is part of the statute, and that is that just because you are a court monitor or whatever, you are still a mandatory reporter. Right. You are still a mandatory reporter, and you are required to do that. Even usins in the judiciary were required to do that.
Well, the few times I've had DCF involved during the hearing on my court monitor's report, I usually clarify it with the judge and get permission to go ahead and share that with DCF and get them involved. And I usually get direction from the judge on that.
I would say that's very nice of you, but you are still legally required to report. If I were your judge, I would be absolutely pleased as punch because there would be absolutely no surprises.
I am a mandated reporter, so I never feel the need to ask the judge for permission to do what I am supposed to do by law.
But it is awfully nice. It is very professional of you. And I would recommend you continue to do that.
Okay, I don't see any other hands up. Kimberly, is that, do you see any other hands up that I'm missing?
No, you are correct. I do have the list of those for public comment. If you would like, we can go ahead and start into public comment. Oh, wait, I see that Ms. Miller raised her hand.
Shannon, do you have another question?
I actually,
tell
at this
Shannon.
time,
Go ahead,
I'd like to make a motion to add a court monitor provision to the task force report and recommendations. I know any motion needs to be in writing. I've gone through and it basically with a little brain trust tried to figure out what they're doing in Broward and put it into 744.107, the statute, and turned it into some proposed legislation. I'd like to make this an oral motion, but I'm gonna send an email to the task force that explains that proposed legislation, and I hope that the panel will consider it and potentially vote on it at the next hearing that we have.
I would be very concerned about any legislation that basically treats everything as one thing for all.
Well, let me, Judge Rodriguez, let me address the motion first. As Shannon knows, she's an experienced litigator, and as Clerk Burke and Tom Hall have so eloquently explained, you have to submit those motions in writing for the task force to consider. So I would encourage you to go ahead and do that, and I think it's a very worthy topic for future discussions. Yeah, that would be good. We'll look forward to your email, Shannon.
And I will work with Shannon because I think we can come up with a process, a legislative process where we do not have one size fits all.
Outstanding.
And just as a reminder, the motion does need to be submitted 10 days prior to consideration, just for your timing, so that you know for the next meeting.
I just sent it. So I just hit send on the email, so it's gone out to the task force members, so everybody will have a chance to look at it for the next meeting.
Thank you so much, Shannon. I see Hillary's hand up.
And I would just like,
just
give me 1 second, well, maybe 4. A few people are contacting me with issues on being able to enter questions for public comment. So I don't know what the issue is, but I've had 3 people saying they'd like to make public comment and are unable to. So thank you. I'll put myself out.
Yeah, thank you, Hillary. Prior to you getting on the,
Oh, I was going to say, Hillary, I'm not sure. Are they having trouble submitting it through the website or putting their name on the list for when we call on them for verbal comment?
I'm under the assumption it's putting their name on the list.
You just need to mark your name or just use the chat feature, and I will add your name to the list. I've got a running tally here, and we will start in just a moment. So as soon as they put their name in the chat, then we will be good. And
okay.
I would also just like to point out again, we are only doing video for the task force members, and so please do not turn on your video unless you are a task force member. And with that, Mr. Vice Chair, would you like me to list off the first person for public comment?
Absolutely. Thank you. Thank you so much.
Absolutely. And just a reminder, we have 3 minutes, and I will remind you when you have 30 seconds, 10 seconds, and time. The first person we have on our list is Heather Kirsten. And Heather, if you would like to unmute your line.
Thank you so much. So good afternoon, everyone. I want to thank everyone for their time on this task force, the task force members and all the people that are participating. I am an elder law attorney. I've been board certified and I've been practicing for approximately 15 years. I practice in the Orlando area. I want to share with the public, and my heart goes out to all the people that have so much pain about how guardians have negatively affected them or their family members. And I want to acknowledge that pain. I understand it. But I want to assure you that most attorneys, including myself, only go to guardianship when it's the last option. It's never our knee-jerk reaction to file for guardianship. We always try to do less restrictive alternatives. We try to get a care manager involved if possible. Our goal is to ensure that the AIP, alleged incapacitated person, is safe. That's our whole goal. I went into the practice of law after being an associate geriatric care manager to help people. And that's my pole star in my practice. And for the attorneys I train is to help people. Now, sometimes we have very ugly situations with very dysfunctional families where people are upset about the guardianship, but it's always to protect the elder. And I would ask, I read the public comment here in the chat, and it holds out judges, attorneys that do this kind of work as villains and criminals. And I take issue with that, because I can't tell you how many pro bono cases I have that I work on for years until the ward passes away. And I can't tell you how I put myself in danger doing this work. I've been threatened. I've been harassed by disgruntled family members, one of which barricaded herself with her disabled son against the sheriff and stole hundreds of thousands of dollars from her disabled son. And we got him out of that situation. We got him in a loving group home. He wasn't eating food. They were pureeing McDonald's food for him, and he lived on a mattress on the floor. And when we got him placed in the group home, he could eat real food. And he was participating on a social level in the group home and with the community on a way he was never allowed to do. So there are bad seeds out there. I acknowledge that fully, but I think we have procedures in place to address those bad seeds, as was much talked about today. The court monitor, I think the court monitors are amazing. I think that's a huge asset we can use. Also, elder caring coordination can be utilized to help mitigate some of these hard feelings. Did you say time?
Yes, ma'am.
Okay, thank you so much for hearing me out. I appreciate participating.
Anthony, you're muted.
It wouldn't be a virtual event without me being muted. So up next, we have Twyla Sketchley. Twyla?
Hi, I want to thank you all for the work you're doing. I think this is vitally important to improving guardianship in Florida. I have been an elder law attorney for 20 years. I'm board certified in elder law. I have been a court expert in several courts regarding guardianship. I have written chapters in textbooks. I have served as an expert for the Office of Public and Professional Guardians in the discipline of professional guardians. And I want to second, first of all, what Heather just said about the importance of guardianship. And I do take issue with the villainization of attorneys and court monitors and judges in the guardianship arena. I myself have been stalked, doxxed, and harassed by angry, upset family members. My husband has been stalked. So we put ourselves in danger every day to do this. Now, I want to speak about the court monitor program because I have served as a court monitor in numerous cases over the past 20 years. My work as a court monitor has helped courts expeditiously remove bad guardians, family and professional, recover assets for wards who've had their money stolen, and place wards in more appropriate, less restrictive care. My work as a court guardian, much of it goes unpaid because, as you've heard, oftentimes there's not any money left in the ward's estate. I think that the court monitor process is hugely underutilized for various reasons. First, I don't think the judiciary or the clerks understand the court monitor process, and I don't think they are aware that it's there. So that's the first issue. I think second, that judges hesitate to use it because they believe it will cost the ward, even though that's not, as you heard, the way it should be. Finally, I also think that it is underutilized because circuits can't, in which I work, can't afford to hire an employee. So they have to rely on people who are willing to serve, like myself. And when we serve, we end up absorbing oftentimes extreme costs of financial and medical records. We are, again, threatened, villainized, doxxed online, etc. for our services. So I actually support improving the guardianship statutes to allow court-appointed independent monitors who can be paid by bad actors, who can be paid by the state, and who can, if necessary, in certain circumstances, be paid by the ward. Thank you.
Thank you. Thank you so much. Thank you so much, Twyla. Next up, we have Britton. And Britton, can you please tell us your full name for our record, please?
Sure. It's Britton Swank. I was trying to get my last name in there, and I guess much like you with the speaking while you're muted, I was having some technical difficulties as well. I had an opportunity to listen at the last prior meeting, and I just want to echo what the elder law attorneys that spoke earlier also said. I am an elder law attorney. This is a second career for me. I went to law school after a family member of mine suffered from memory impairment. And I find that a lot of attorneys in this practice area do it because of a love for this particular portion of our community, people that are most vulnerable and are drawn to helping people that are disabled and are vulnerable. And it is always part on the estate planning side of my discussion with my clients, all of the reasons why they don't want to find themselves in guardianship court. And it's because I want them to maintain their dignity. I don't want their private matters shared in court one day. I don't want their family to go through the expense. But ultimately, despite the best of planning, sometimes, whether it's because of behavioral issue that becomes dangerous to themselves or dangerous to other people, or it's because someone has chosen the wrong person as their financial decision maker, guardianship is the only option to protect them. And I also believe that professionals of some sort are an important part of this process, because unfortunately, in many of the abusive situations that I've encountered, whether that's financial, verbal, physical abuse, the perpetrator has been a family member. And I think we need to recognize that there are, unfortunately, family units where there is not a viable candidate for a fiduciary, whether it's an agent and a durable power of attorney, healthcare decision maker, or as a guardian of a vulnerable person. And as everybody works toward finding a better way to help, as you said, level the playing field, I think that that really needs to be a strong consideration, because unfortunately, family members are not a safe option all of the time. Thank you.
Great, thank you so much. Up next, we have Dr. Sam Sugar. Dr. Sugar?
I'm unmuted now. Good afternoon, everyone. I've listened very attentively.
Good afternoon.
I'm sorry?
I just said good afternoon, Dr. Sugar.
Oh, okay. Good afternoon. I've listened very attentively, as I have at every one of these meetings, and I've heard some amazing people say some amazing things. And I can't speak without complimenting Judge Cohen, who is an incredible breath of fresh air in this conversation. God bless you, Judge Cohen. I would only say to
Grammarly helps. This sentence is grammatically correct, but
I don't know what that is.
to read.
Well,
Yeah,
see,
okay.
Kimberly, can
The word choice is
Yes,
bland.
I'm just scrolling down. Someone unmuted their line.
I want my time back, too. I'm extremely impressed with what Judge Cohen had to say, and I'm extremely concerned by what other people have had to say. As those of you who've heard me talk before, I've been involved in guardianship now for a decade, and there are some very serious problems. Otherwise, we wouldn't be doing this. If the attorneys are concerned about threats to them, put yourself in the shoes of the advocates. I've had death threats for a decade. It doesn't stop me from what I'm doing, and I don't make money by doing it. And that's my point. The financial remuneration for getting involved in this process, whether it's from the courts or private practice of law or court monitor or anything else, are what drives the abuses. And until we recognize that it is the money involved in these large multi-million-dollar cases that enrich the court predators, and I'm going to use that term, because while there are many excellent lawyers who do a wonderful job, and God bless all of them, and God bless all the guardians who do a good job, the system is infested with predatory lawyers whose main goal is not the safety of the individual, it is their pocketbook. And once we get rid of the financial incentive to abuse wards in this paternalistic, ageist system and do it right and set up a system where people who need help get help, then we won't need this task force, and we won't need the court monitors, and we won't need this entire superstructure that's designed to continue the business of guardianship. I encourage all of you to keep going. I know I've said that guardianship can't be fixed, it
30
needs to be
seconds.
abolished, and I still feel that way. It's an imperfect system. But until groups like this put their voices out there and understand the deficiencies in the system, which are legion, it will only get worse. Thank you all very much for taking the time to listen.
Thanks, Doctor.
Thank you so much, Dr. Sugar. Next up, we have Jane Provost, and then after Jane, we have Dr. Teresa Kennedy and Marcy Friedman. But Jane Provost, you're up now.
Thank you. Good afternoon, everyone. My name is Jane Pronovo, and I'm a professional guardian. I appreciate the opportunity to speak with you today, and I applaud you for looking at ways to further protect those vulnerable to exploitation. All too often, a guardianship is put in place because the senior is being taken advantage of by those who should be protecting them. These include friends, acquaintances, and sometimes family members who are fighting over their future inheritance. We are all appointed when family are unable to be the guardian for one reason or another, and there is no one else left to serve. Obviously, in these cases, the guardian faces the ire of the exploiter. One of my first cases involved a family member who was a power of attorney. He sold 2 homes with a value of $500,000 and used those funds to send his daughter to an elite university and give lavish $10,000 birthday gifts, and more. When a sister got suspicious because she could not get in touch with her mother, a guardianship ensued. The ward had been removed from the facility and was found in his apartment on a mattress on the floor, and the ward was thereby returned to the facility. I tried to file charges, but even though there are laws on the books regarding fiduciary responsibilities, I was told it was a civil case. However, this family member was not happy with the guardian and decided to report me to the CIA, the FBI, that I was conspiring with the Rockefellers. Another case, a gentleman had named his daughter as a POA. She went out and purchased a home for $250,000, furnished it, and wrote checks to her cousin for several $1,000s. The financial exploitation was immediately stopped and a settlement was reached for the daughter to return the funds to her father. In these cases and much more, I was able to curtail the exploitation of the vulnerable senior. In other words, the bleeding stopped. I have been threatened, stalked, family sat outside my office and my home, and we are always under constant awareness of our safety. Unfortunately, there are bad seeds in every profession, including guardianship. One of my suggestions is for additional training of guardians, especially regarding ethics and fiduciary responsibilities for both family and professional guardians. Another suggestion is to require quarterly financial accountings rather than waiting an entire year. The Agency for Persons with Disability uses this process with their support staff. This will provide a more timely review of the clerks.
30 seconds.
It will also make it easier and quicker for the clerks to identify any discrepancy and resolve it quickly. Once again, I applaud all of you for taking the time to tackle these difficult issues and allow me to provide my comments today. Thank you.
Thank you so much, Jane. Next up, we have Dr. Teresa Kennedy, followed by Marcy Friedman, and then Sherry Johnson is next. Dr. Kennedy, you're up.
Yes, thank you, Anthony. This is Dr. Teresa Kennedy, founder of Elder Dignity. My family's also been a victim. My aunt was Dr. Lily Sykes White. I have a comment related to, first of all, thank you for the presentations. My comment has to do with OPPG. And Shante Jones laid out a process that sounds reasonable, but in practice, it has not been effective in actually protecting seniors. My analogy is if a guardian of a child has violated the law, would we keep that guardian in charge of the child, even pending the investigation? And that's what happened in my aunt's case. There had been violations. The guardian was kept there, and it led to my aunt's isolation, exploitation, and death. And so let's look at, that correlation between what we would do for a child, how we would protect the child, and what we would do or not do with the senior. The other comment is, and then OPPG should have a statutory power to actually do something quickly to protect the senior. And the second comment has to do with once a violation is found, it seems to go into a dark hole. And so there needs to be some other transparency in the process of how we get to prosecution, as well as relief for the victims. My last comment has to do with Dr. Sugar's comment. I absolutely concur with taking the profit motive out. That is the crux of the exploitation. If all the attorneys were not getting paid, the court-appointed attorney, the guardian ad litem, the court monitor out of the ward's estate, I think they would probably go away. And we would see who truly wants to protect the senior and the disabled. So we have to work on the profit structure around this industry because it is an industry. Finally, let's remember that it's the senior and the disabled person we're trying to protect. That person should be at the center. How can we add more voice in? And during my aunt's situation, we had video and audio and all these different things, but no one listened to her. And so how can we require the ward's voice to be heard? process. And the last comment is generally, we need more citizen oversight in some way. I don't know how that happens, but I just want to put that forth. Thank you for the task force, and let's take the profit motive out.
Thank you, Dr. Kennedy. Next up, we have Marcy Friedman, followed by Sherry Johnson, and then Myrna Ramos. Marcy, you are up.
Okay. Thank you very much for everyone in participating to create positive changes. First, I want to say, I've also been targeted. I'm a victim, and so is my vulnerable mother. For a daughter to seek guardianship to protect her mother, her only daughter and next of kin. My mother, thank God that I think having these hearings facilitated a visit that the honorable judge finally signed the order so I can be supervised to visit my mother and pay for it. But she's worth every penny of it because, thank God, she still remembers her loving daughter, and she is now with tears of joy. I think that I totally agree with Teresa Kennedy, everything that she said, and Dr. Sam Sugar. There needs to be a cap on the amount of money that is collected from the vulnerable, because it goes around in a circle. And I am a daughter who doesn't even have a criminal record. I don't even have a speeding ticket. And all I've ever wanted was to protect my mother, who suffered isolation, who suffered negligence. But thank God there's a God and there's justice. And I believe that everyone in this task force should put themselves in my shoes, in my mother's shoes, in Teresa's, Mrs. Kennedy's shoes, and everyone else that has been injured by this process. So today, I want to thank you from the bottom of my heart and from the bottom of my heart of my mother, because she and I never have had a problem. And to take in consideration when someone gets evaluated for mental capacity, it should have the records from the past doctors and CAT scans, because that is being protecting the vulnerable elder. Thank you very much.
Thank you very much, Ms. Friedman. Next up, we have Sherry Johnson. Sherry?
Yes, sir. Can you hear me?
Yes.
Okay. My name is Sherry Johnson. I am an advocate from the state of Texas. I just want to let you know that not only Florida have many issues with their guardianship program, Texas and other states across the nation have just as many problems as y'all do. The thing I want to comment is what's been reported is being unreported. The system is probably 1,000 times more broke than what y'all are seeing. Y'all are only seeing the part that y'all participate in the courtrooms. Y'all see each other as attorneys and doing legal procedures, and you don't see as these attorneys are taking family members out of their own environment and place them in there with strangers so that the strangers called a guardian can abuse and exploit and warehouse their loved ones. That's where most of the trouble comes in. And my question to all of y'all is this: why do we even need a guardian? There's alternatives to guardianship. If you have money, they have trust that you can create, protect the money, put a trust officer over the trust, which is done every day to protect the person from the family members. And also, what does the guardian do that another member of the family can't do? When you become a guardianship, the guardian, the judge does away with all your legal paperwork and assigns a guardian to be your power attorney, over your estate, over your personal, everything, when the other organizations that can do this and terminate not being into a guardianship. And my next question is, if my mother was in a guardianship, was very abusive. At first, we started out kissing the guardians behind to make it as pleasant as it could be. And our attorney told us that if we didn't agree with what she said, it would cost my mother hundreds of thousands of dollars in attorney fees to object to the guardian. And as my mother eventually got abused, we stepped up to the plate and we filed complaints. And in Houston, we had ex parte hearings. We had the court coordinator retire and becoming a professional guardian. They switched guardians to the professional court reporter guardian. At the end of the day, my mother was forced to death on a hospice program. The doctor didn't even know what was going on. The day that my mother was put on hospice, the court coordinator / guardian gave the judge a $150 campaign contribution. All the attorneys involved gave the judge $1,500 to $2,500 campaign contribution. And the guardian ad litem was appointed associate judge to the judge that oversees my mother. So I'm just here to say the system is very broken, and I don't see how y'all can justify guardianship anywhere when there's alternatives. Thank you for your time, and God bless y'all.
Thank you so much, Sherry, for your comments. Next up, we have Myrna Ramos. Myrna? Myrna, if you're talking, you may have your line muted. Myrna?
I just sent the request to unmute because she is still muted on the Webex, but it would need to be done on that end. Oh, there we go.
Right. There you go. Myrna, are you there now? We seem to be having a little technical troubles with Myrna's line, but you both need to be unmuted on the Webex, and also if you're calling in by phone, you need to be unmuted on your phone. Myrna, did you get that sorted out?
At one point, there we go, unmuted on the Webex. And now muted again. Myrna, okay, now you are unmuted on the Webex, and so I think it would just be the audio on your side. Okay.
Kimberly, do you want to unmute the call-in users to see if there's any questions? I've got, I want to be very respectful of the task force members' time.
Hello.
I think,
is that Myrna? Okay,
yeah,
very good.
Hello.
You're up, Myrna. Yep.
Can you hear me?
We can hear you. Go right ahead.
Oh, good. Okay. I had advocated for a dear friend of mine. She was placed in the hospital on April 7th, and there was absolutely nothing wrong with her. She stayed there for 81 days. And from there, they put her in an assisted living facility. I reached out to her court-appointed attorney. And then after my meeting with her court-appointed attorney, the court-appointed attorney called the hospital where she was at and did not allow her to have any visitors or phone calls until she was discharged from the hospital. What kind of an attorney is that takes away the privileges of somebody? And then I even witnessed one of her assessments at the hospital along with my friend. We were there in the hospital room when she was assessed, and she answered every single question that was asked of her. And then we were kept from seeing her. We would call the hospital. We want to speak to her. Oh, she's no longer in the system. You go in there in person to visit her. She's no longer in the system. And then she was placed with a court-appointed guardian who was another one that tried to keep us from seeing her. She was isolated. Everything taken away from her. I have pictures. I have videos. I even reached out to the governor. And this is the most corrupt system that I have ever witnessed in my entire life. And as my friend said, there is a God up there. But you know what? Something has to be done to protect our elderly. And not just from family, because there's good family and there's bad family, and there's friends that do more than just family. But the number one predators to me are the judges, are the guardians, are the doctors. It all starts with them. How can you assess somebody and say, oh, they're incapacitated? When I witnessed her assessment. And when I told her court-appointed attorney that, you know what she did? She asked me to leave her office and then to forget about my friend because I could get myself in trouble. Because I wanted to advocate for her, I could get myself in trouble. She even executed new power of attorney, which I have in my possession, and the attorney would not accept them. So what can you tell me? What can you tell me? Her human and her civil rights were violated. And where is he at now? He passed away in January. But you know what? God let me be with her right before she died.
Thank you so much for your comment, Myrna. Okay, Kimberly, if we can unmute the lines and see if we have any other of our call-in users that want to make a comment. I know we're a little bit after 2 o'clock, and I do want to be respectful of everyone's time. But on the other hand, I want to make sure that, everyone's heard that wants to be heard. Do we have any call-in users?
Yes, I'd like to make a comment.
Go ahead and identify yourself for our record and go right ahead.
Thank you. My name is Susan Melendi. I am a guardian advocate. I also have a nonprofit, Justice for All Florida, Inc. I agree with some of the statements made earlier that definitely we have to take the financial incentive out of guardianship. I always say follow the money. It's a huge problem. We currently wrote a bill with Charlie Crist and Nancy Mace that's going into legislative session coming up. And we're advocating for some type of a guardian advocate that reaches out to the individual in the very beginning to avoid court altogether. Most people that we are involved in from an advocacy perspective have family members that take care of them and love them and are available and are healthcare surrogates. The people have advanced directives. The only incentive to put these people into guardianship is the finances, and by time all of the litigation is done, the money for the individual that they work for their whole life is gone. And that's wrong. That's not fair. That is certainly not in the best interest of the ward, and that's not in conjunction with Florida statute. A simple law like the ability to substitute for an alleged incapacitated person needs to be challenged in the second DCA, because a judge can simply decide, yes, I'll do that for people that I want to do it for, but no, I'm not doing it for people that are going to come in and make a difference for the ward, the potential ward, and fight for their rights. People are losing their rights. When they come in and they win for the financial rights, they'll swoop back and go after the person. When they don't even ask the person what they want. They don't even speak to the person about their wishes. And that's who needs to be heard. It's just simply wrong. And we're destroying not only the lives of the elderly and the most vulnerable, but their entire family. And family dysfunction is not the prerequisite for guardianship. That is just a guise. Not everybody's family is Ozzie and Harriet, but when people have advanced directives, they don't get to be thrown out. A DPOA does not get to be thrown out because there are siblings that don't agree with their parents' advanced directives or financial plans. There's always somebody that's, taking the responsibility for the parent and the loved one, and most times the other siblings just don't like it. That's not the prelude to guardianship, and it's used every day. Thank you very much for all your consideration.
Well, thank you so much for that comment. Again, I want to be respectful of everyone's time. We went 5 minutes over. If you know me, I'm a pretty punctual person. So we're going to end the comments here. If you have any additional comments, I encourage everyone to please go to the website and submit the public comments through the website. I really do think we are hitting our stride with the presentations and especially the public comments. And I am truly looking forward to continuing this conversation and the good work being done by the task force for raising these issues. And I want everyone to take note of the prior notification of the date change for the in-person meeting. The meeting will be held in Tallahassee at the Turnbull Center, and additional details will be sent to the task force, and we'll also post that information on the website very soon. With that, I want to thank everyone, all the task force members and everyone that is watching this on the Publix line. And I thank you and have a wonderful day.
Any chat transcripts available later? Hello?